Are you an immigrant spouse married to a United States citizen who has mistreated you, who has abused you, and perhaps even perpetuated physical violence upon you? Recently, you were told about a program, VAWA, the Violence Against Women's Act program, that could protect you from such violence and perhaps lead you onto a path of immigration benefits, including permanent residency. But you fear applying would lead you to a dead end and deportation. After all, your spouse has told you that without his or her help, there is no way you could win a green card. Well, that's not accurate. Of course, when you apply for any immigration benefit, including VAWA, there's a possibility that you could lose, and losing would subject you to perhaps fighting off deportation. But in the VAWA context, there are various options that, should your application be denied, you could still prevail. And in this presentation, I want to share those opportunities for you. I want to share those options so that you can make a more complete assessment as to whether you want to apply for VAWA or not, so that you know more about your chances of prevailing. And should you not prevail the first time around, your chances of overturning an adverse decision. In order to best assess your chances for success after your VAWA petition has been denied, there are two preliminary matters that should be looked at. First, what are the proceedings that your case is involved in? Secondly, what were the reasons given by the government for the denial? Let's start with proceedings. Generally speaking, there are three areas in which VAWA applications, VAWA petitions arise. First, there is the affirmative petition, the I-360 petition that is sent to an immigration service center. That is the subject of this video. Secondly, a VAWA petition may arise in the context of immigration court. Let's say you're referred to immigration court to face deportation charges. You raise VAWA as a defense. That's considered a defensive filing. That VAWA is considered VAWA cancellation or removal. Third, perhaps you obtained a green card less than 2 years ago and you have to remove conditions on it. That petition is supposed to be filed jointly with your spouse, but you and your spouse have had problems, and so you raise VAWA, domestic abuse, as a reason for seeking a waiver of the joint requirement so that you can proceed alone. The latter two instances, VAWA cancellation removal and VAWA under an I-751 filing, I have included links for below this video so that you can look at those issues in more depth. In this presentation, as I noted, I'll be focusing on the I-360 affirmative application filed with a service center. Let's look now at what are the common reasons that the government often denies I-360 petitions. The first is that you haven't proven that your marriage is bona fide, that it was in good faith, that it was legitimate. Second, the government may feel that you have not presented enough proof of the domestic abuse, of the violence or extreme cruelty. Third, the government may feel that you haven't shown that you had any joint residency period with the abuser. Fourth, the government may question the abuser status. Now, under VAWA, you can proceed if you were married to either a U.S. citizen or lawful permanent resident, but you haven't shown perhaps sufficient proof of either status of the abuser, and so the government issues a denial. Fifth, good moral character issues. Perhaps you have former criminal blemishes, or you had some immigration problems, or there's some other issues bearing on moral character that the government has spotted, and as a result, they ended up denying your application. In any of those situations, they could be combined, the government has denied your I-360 petition. Now I would like to discuss four general categories of responses that you could possibly take if your VAWA petition has been denied. The first is do nothing. Now, you may ask, why do I say do nothing? Well, perhaps you utilize the services of a paralegal or notario or someone, and they just made a horrendous amount of mistakes that you can't easily clean up. And clearly, those mistakes show you're not eligible. So you walk away, you do nothing until you can get everything you need to proceed forward. Sometimes there's also the possibility that there may be legal issues lurking around the corner that you don't want to deal with right now, and that when you originally filed your I-360 petition, your VAWA petition, you didn't realize that those problems could become nightmares later. The second category is to challenge the decision legally. There's a couple of ways to do it. You can file a 290B, a USCIS Form 290B, motion to reopen or motion to reconsider, or a combined motion, or you could file an appeal. A motion to reopen is based on missing facts. Perhaps there were facts that you couldn't get a hold of in time when you filed your VAWA application, and you couldn't give the government the information they needed. But now you have that information. Those could be reports from, say, a police department or medical reports or from a shelter. You just couldn't get them. You're going to have to prove, though, that they were previously unavailable. Because if they were not previously unavailable, then the government might still reject your application. A motion to reconsider, on the other hand, is based more on a legal misinterpretation. For instance, you may have had a prior conviction that the government found out about, and so they're raising that as an issue against you. However, that conviction was directly related to the abuse you suffered. Your spouse, your U.S. citizen or permanent resident spouse, forced you to commit some crimes and you got in trouble, and there's fairly good documentation of it. And you may also be eligible for a waiver. Sometimes the government overlooks the fact that you may be eligible for a waiver. Doesn't mean you've been granted the waiver, but you're eligible. If so, then a motion to reconsider may be the way to go. Now, you can combine both motions to reopen and motions to reconsider, and that is a maneuver, a legal maneuver that I highly recommend in most situations. The other legal option is you could directly file an appeal with the Board of Immigration Appeals. For instance, you may have been denied, say, based on shared residency, that the government's claiming you never lived with your spouse for during the period that you say the abuse occurred, and it may be based on a prior application that you filed in some other context, or that your spouse filed in some other context, and there's some error that's wrong there, and that's a misinterpretation, but it's also a factual mistake, and it raises an issue of fraud for the government. And so you want to contest that fraud. You may want to then file an appeal. So it depends on what the denial is based on if you're going to challenge it legally. Think carefully about those options. A third category is you could refile. And this goes hand in hand with the first criteria of doing nothing. Perhaps you do nothing, but later, you find out what was really messed up in the application, what was really flawed, what the person's helping you or what you did on your own just was terrible. And so, but you can clean it up. So instead of going through the legal maneuvers because you can't prove that the government misinterpreted anything or that there were missing documents that you couldn't get on time, so you refile. That's a third category of responsiveness. The fourth one is other options. You might qualify for a U visa as a victim of crime activity, or a T visa. You're a victim of trafficking, or even asylum. But those those options you're going to need to talk to an attorney about, because those are highly technical and they sort of veer a little from the strict VAWA case, and you shouldn't go forward on those unless you've at least first discussed those opportunities, those options, with someone that specializes in immigration law, so that they could help guide you in that process. So, those are the four potential responses, the four general categories responding: do nothing, challenge it legal, refile, or perhaps pursue another option. So, now we can return to the central concern. What are the chances that if your VAWA petition is denied, that you will be deported? Well, the reality is this: whenever you file anything with immigration, whenever you're trying to obtain legal status, there's a possibility that you'll lose, that your petition or application will be denied. And as a result, you may be referred to immigration court to face deportation charges. And in fact, when the government reviews applications, it is not uncommon for them to go beyond just the application. They'll look at other matching data in their computers for other applications, either of the immigrant spouse seeking benefits, or the U.S. citizen or permanent resident spouse who has submitted paperwork, or they may look at certain criminal records. So there's always a risk of deportation in that sense. However, given the possibilities that you have for challenging errors, if you don't really have serious problems, then going forward is less of a risk. But the reality is, there's always some risk. And there's a few thoughts I have in terms of that. A lot of individuals say that they want to file a VAWA application at the same time that they file an I-485 adjustment of status to green card application. That's possible. In a lot of cases, I don't recommend that, because think about it this way: if your VAWA application is denied for any reason, then your I-485, your permanent residency application, is also going to be denied because the petition was not approved. And when the I-485 is denied, it's going to be denied more at a local level, where it can be referred to immigration court to begin removal proceedings, deportation proceedings. So there's a greater risk that the I-45, the permanent residency application being denied, is going to lead to you having to face immigration charges. So the joint VAWA adjustment of status application is something that you might want to reconsider. I know there are those attorneys and others who recommend that. I think it increases the risk that you'll be facing should something go wrong. The second thing is the immigration priorities, and I want to talk to you about that. Depending on the administration's priority, President Trump, President Biden, different priorities in a lot of instances. And so, under Trump's first term, he was referring cases, his administration was referring cases that were denied more quicker, faster, directly to immigration court, so that immigration proceedings could be started against the immigrants. Why? Because he's not a pro immigrant president. And so he was seeking a way to move people out of the country faster. So sometimes the administration, and even if it's a friendly administration, they might have policies in place on certain cases where they're going to refer cases that are denied to immigration court. For the last several years, VAWA applicants haven't faced that problem. But with the Trump administration now coming back into office, that could be an issue. And in fact, it probably will be an issue. I don't think there's a could. I think that it most likely will be an issue. So if there's questions when you file, you need to make sure you get those looked at very carefully by an immigration expert, someone that knows VAWA law, so they can look at that before you file and put yourself at risk. Because the issues that a strict administration, like a Trump administration will look at, goes beyond just looking at whether you had any past convictions or any past immigration problems. The issues that we mentioned before, in terms of what you could do in terms of reopening or appealing a case, that you had a previous application, there was incorrect information that might not have been matching, that maybe you had some eligibility issues in terms of proving that the abuser was a citizen or a permanent resident, or that the marriage was bona fide, that it was legitimate. Those kinds of things under a strict administration might lead to fraud allegations, and therefore people would be referred to immigration court to face fraud allegations, as well as the fact that they may not be residing in this country lawfully. So those referrals to immigration court, you're going to have to worry about. And so, yes, again, that means there is a risk of deportation. Now, an immigration court, though, remember at the outset I mentioned cancellation removal at immigration court, VAWA cancellation removal. And as I said, I'm attaching a video below on that subject. At immigration court, let's say your case was denied a USCIS because you've been divorced more than 2 years, and so USCIS denies the application. Well, VAWA at immigration court has some different rules. And one of the rules is that even if you've been divorced more than 2 years, you might still be able to seek VAWA as a relief, VAWA as a way out of deportation. So you may be totally locked out in terms of filing a new petition affirmatively with the service center, but you might be able to renew that case at immigration court because the rules are slightly different. And as I said, I have a video on that subject. I would suggest that you review that carefully. So when you're considering going forward with your VAWA petition, or if you've already gone forward, all immigrants, all cases, all immigration cases have a fight or flight aspect to it if denial happens. You can either fight it or you can back off for a while. And so I hope that this video has given you some ideas on what might arise as potential problems and what your potential solutions are in terms of proceeding forward and challenging the government or restarting your case. I hope that I've given you advice that you can use that helps you on your path to becoming a permanent resident, and one day after that, becoming a United States citizen. With that, good luck and take care. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below, or feel free to contact me at carlos@VataraImmigrationLaw.com. My name is Carlos Vatara. I appreciate your time, and hopefully we'll be talking again very, very soon.